Welcome back to Court TV Live. I'm Michael Ayala. It was a surprising turn of events in the Judge Jumper attempted murder trial in Las Vegas. Defendant Deobra Redden pleaded guilty to all of the charges, including count 1 of attempted murder. Let's get you back into court now, where the judge is addressing the defendant.
You also understand that you are eligible for probation with respect to those other counts?
Yes.
As well as count 3?
Yes.
Your Honor, I think count 7 is actually non-probationable.
Okay. Okay. I will get to count 7. I thank you, counsel, for doing that. You are not eligible for probation with respect to count 7. We will get to that in a few moments. Do you understand that?
Yes.
Okay. With respect to count 4, do you understand the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 2 years and a maximum term of not more than 10 years?
Yes.
Do you understand in that instance you may be fined up to $10,000?
Yes.
With respect to count 5, do you understand that the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 1 year and a maximum term of not more than 5 years?
Yes.
Do you also understand you could be fined up to $10,000 with respect to that count?
Yes.
With respect to count 6, do you understand that the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 1 year and a maximum term of not more than 6 years?
Yes.
Do you also understand in that instance you could be fined up to $5,000?
Yes.
Okay, and that again is with respect to count 6. With respect to count 7, do you understand that the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 2 years and a maximum term of not more than 10 years?
Yes.
Okay. And you do understand that you are not eligible for probation for the offense to which you're pleading guilty with respect to count 7?
Yes.
And do you understand you could also be fined up to $10,000?
Yes.
And in any case, that the law does require you to pay certain administrative assessment fees?
Yes.
Do you also understand the court may order you to make restitution to any victim of the offense to which you are pleading guilty?
Yes.
Has anyone threatened you or forced you to plead guilty but mentally ill?
No.
Has anyone told you if you do not plead guilty but mentally ill, some other adverse action will be taken against you?
No.
And I take it that you have you've received a copy of the guilty plea memorandum?
Yes.
Okay. And your signature is affixed thereon on page 8, is that right?
That's true.
And your lawyer, Mr. Arnold, he signed the guilty plea memorandum on page 9?
Yes.
Prior to signing the guilty plea memorandum, did you read it?
Yes, I did.
Did you discuss it with your lawyer before you signed it?
Yeah, I did.
Did he answer all of your questions?
Yes, he did.
Did you sign the guilty plea memorandum willfully, knowingly, and voluntarily?
Yes.
Do you feel you understand the terms of the guilty plea memorandum?
I do.
Has anyone made any promise to you other than those set forth within the guilty plea memorandum that induced or caused you to plead guilty but mentally ill? Sure. Has anyone made any promise to you other than those set forth within the guilty plea memorandum that induced or caused you to plead guilty but mentally ill?
No.
You understand that later on, when there are requests with respect to sentences or any sentences that may be agreed to by your lawyer, and the lawyers for the state would not be binding upon the sentencing judge?
I don't understand what that means.
Do you understand that sentencing is totally up to me?
Okay, yes.
That's irrespective of whatever your attorney argues to me. If later on there's deals made between your lawyer and the lawyers for the state, I don't have to abide by those deals. You understand that?
Yes.
Okay. And do you also understand that you might, on the basis of your guilty plea but mentally ill, receive, if there was any deals going on, that you could receive a more severe sentence than that, either requested, recommended, stipulated, argued by your lawyer?
Yes.
Okay. Do you have any questions as to what you're alleged to have done within the second amended indictment?
No.
Do I need to review all that with him?
He's never been canvassed as to count one, Your Honor. I think the parties can agree to incorporate the factual basis from his previous plea as to counts 2 through 7, but he's never been canvassed as to count one.
Okay, let me go through that. I don't have that right in front of me, so let me pull it up. I'm going to go through all the counts.
Thank you, Your Honor.
Okay. Okay, I'm looking at the, well, it's called the amended indictment. And it was filed on August 30th.
It's the second amendment that was filed on Tuesday, Your Honor. That's the charging document we're going off of.
Okay. Okay, I need it. Yeah, apparently it was filed in open court, counsel, and I, for whatever reason, hasn't made it yet, but they're going to do it like right this minute.
I'm going to email them right now, Your Honor.
I can email the court a copy if you want to read from it electronically.
If you got a file stamp on it, I'd be happy to do that.
Let me see if I can.
In fact, counsel, would you approach?
Sure.
All right, so you heard the judge there. Essentially, she's not bound by any deal or any discussions that would have happened between the defense and the state. She can sentence him to what she chooses to. But again, the big headline is he's accepted this plea or agreed to this plea of guilty but mentally ill. And now he has the burden, his defense has the burden of proving beyond a preponderance of the evidence that he is in fact mentally ill, and then they'll deal with it after that in terms of the sentence. Facing, at least according to what the judge said, over 90 total years when you add up all 7 of the counts and the amount of time, the maximum time he can do on those. He's 31 years old, so it doesn't look good. All right, we'll take a break here. When we come back, we'll get you back inside that courtroom. Keep it here on Court TV.
Tonight on Closing Arguments, a man charged with attempted murder after attacking a judge faces a jury. We'll bring you all of today's key moments as our experts weigh in.
Closing Arguments with Vinny Politan, tonight at 8/7 Central, only on Court TV. Join Court TV's Vinny Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinny Politan Investigates, tonight, 9/8 Central, only on Court TV.
All right, folks, we are continuing our coverage in the Judge Jumper attempted murder trial in Nevada. Defendant Deobra Redden unexpectedly pleaded guilty to all the charges, vacating his previous plea and entering a new plea. Well, let's get you back into court now, where the judge is still addressing the defendant.
Okay, at this time, I am going to allow Mr. Redden to withdraw his original guilty pleas to counts 2 through 7, and it is the finding of the court the defendant is fully competent and capable of entering an informed plea with respect to the 7 counts, and that your plea of guilty but mentally ill is a knowing and voluntary plea supported by an independent basis in fact, containing the essential elements of the offense charged, and for that reason this court accepts your guilty pleas. We need to give this gentleman a sentencing date.
Yes, and I believe the defense counsel was requesting 60 days.
Yes, Your Honor.
60 days?
Yes, Your Honor.
I think we can accommodate that.
Court's indulgence, Your Honor.
Sure.
Judge, just for the record, was the Mr. Arnold's acknowledgement attached to the guilty plea agreement?
I've got it. Yes.
Just wanted to-
Certificate of counsel?
Yes.
It's there.
Thank you.
Okay. And go ahead.
November the 7th, would you like a special time, Your Honor?
Do you want a special time?
Yes, please.
Usually I have my calendar at 8:30. Do you want to do it after? Or do you want to do it in the afternoon?
We can do 10:30 or 11, or we can do the afternoon. whatever. Afternoon would be better.
Oh, now this shouldn't be a Wednesday.
No, I'm saying on the Thursday.
Okay. Yeah, because I have gotten where I just don't settle on. There's just no way I can get it done. Right now, we've got 6 criminal sessions on that. I could probably do it at noon if you want to just do it at noon.
Whatever Mr. Arnold's preference is.
That's fine, now.
Okay. We'll just take a later lunch, okay?
November the 7th at noon.
Thank you, Your Honor.
Thank you.
Okay, thank you. And Ms. Clerk, I'd like these documents, Dr. Paglini's report, left side filed, as well as Leah Rowley, Dr. Leah Rowley's report, left side filed. Okay? Okay. And thank you very much. Well, wait, Mr. Arnold, do you want to take the defendant out now? I was going to tell the jury.
All right, so surprising events again out there in Las Vegas. Sentencing is now set for November 7th for Deobra Redden. Again, he is facing at least 90 years or so if he gets the maximum on all these 7 charges that he's facing here. Let's bring in our guest, still with us to discuss, his federal trial attorney, Alexis Rosenberg. Alexis, I want to get your reaction to the events of the last 10, 15 minutes. Pretty shocking stuff.
Yeah, wow. I mean, I didn't see that coming for sure. So we've got him entering this plea, which is interesting because, like you said, he's still facing a lot of time. I mean, a lot of time. I think that, you know, he was sitting there with his attorneys and his attorneys were like, this isn't going very well for us. Like we discussed, we said there's pretty damning testimony coming, especially from the judge.
So what do you think was the impetus for the state to decide to deal? Because when he offered the deal a couple of days ago before the trial started, right after jury selection, he took was basically a naked plea where the state wasn't really supporting it and wasn't giving any recommendations, et cetera, et cetera. But now this is an effort between both sides. What do you think might have spurred the state to take this step?
Well, I think the testimony about how from the clerk saying that he was calm and it just seemed like it was a snap, which would be consistent with some insanity that you had this person, he came in, he's very calm, he's talking to different people in the courtroom, and then all of a sudden this happened. As well as I think they had a problem with, you know, the actual who hit who because of the chaos. We know the first one he jumped, and even from the video that you're playing now, we're not actually seeing that he's making contact on this video so much with the judge.
Yeah, and again, as I mentioned, I think there weren't any visible injuries as far as on her head. You know, we heard testimony that he slammed her head against the wall, but there were no bruising to her head, neck area, et cetera, et cetera. So all those things, I gave both sides this sort of impetus to go forward and make this deal. Now, again, comment on the idea that now the preponderance, the burden shifts to the defense now. When they go to sentencing, I would imagine they're going to have to bring in experts to testify that, in fact, there was some mental illness involved here. He's in a good position because there had been a previous diagnosis of paranoid schizophrenia. He even said to the judge as they began, he said, look, as long as I'm on my medication, I'm competent, I can understand and agree to these things. So talk to me about that shifting of the burden here to the defense to prove that there was some sort of mental illness here.
Michael, you bring up a good point. And the judge even acknowledged at one point, she said, yes, we know that you were on these medications and so forth, but that wasn't my question. And, you know, to bring up another point, preponderance is a much lower level. I mean, when we're comparing that to reasonable doubt. So, you know, I think that it's going to be fairly easy for the defense to show that that there was mental illness and that he was on medication. I don't think that that's going to be difficult for them.
Yeah, I would agree.